So I think what's helpful to keep in mind is what is a reasonable standard of care for businesses before we had the pandemic? What was expected of them? And in that case, they would be expected to, if someone was hurt or injured on their property, then someone would be able to file a negligence suit. And if it was found that the injury or illness happened because of that business, then they would be liable for damages with the CDC guidances, with the OSHA guidances, in terms of physical distance, 6 feet apart, wearing masks and gloves. These are all things that would be a reasonable standard of care that an employer could insist on having their employees and customers do before they walk into that place of business, whether it's a restaurant or a nail salon or whatever it might be.
Lately, we're hearing things about temperature checks or perhaps testing for COVID-19 or antibodies. Are those pushing any sort of legal boundaries for someone to request that of someone when many of us believe we have a reasonable right to privacy in that area?
I think it's important that you could still balance these two. You could certainly do those things, such as temperature checks and screenings, in a private way where you're not exposing an individual information out more than absolutely necessary to protect others. I think that there's also ways of triaging your employees and customers. Maybe not everybody has to be subject to the same level of testing, whether it's the temperature checks or self-reporting that that you could do in this circumstance. So let's say it's someone that has less contact with the public. They're not out there as much as others, and they may not be required to have as much screening as somebody else. But given that what we do know about this virus, and we do know it disproportionately impacts an elderly population and those that have chronic underlying conditions, I would say it would be more proactive to really address those individuals first with when we do have limited resources in the testing and screening areas than for the entire workforce.
You know, we're hearing stories about people worry that it's potentially bridging on their individual rights and they're uncomfortable sharing too much information. Granted, this is something none of us have ever experienced given that we're in a pandemic now, but it is fair for the average citizen to question things and then perhaps proceed cautiously because they may not know what to expect in the workplace or at a business.
Right. I mean, it might be helpful at this point to distinguish between what an employee's rights might be from a customer or patron's rights. So let's say your employer says, I expect you to wear a face mask and gloves, or various things that the CDC has advised us will help protect us with limiting transmission of the coronavirus. So an employee, should they then get the coronavirus, they wouldn't be able to sue the employer in that circumstance. They would fall under a workers' compensation fund. But the interesting issue there, which is a gray area, is that typically a workers' compensation fund excludes diseases that are prevalent in the general population. And that's just a very gray area right now. And there could be some exceptions for those that are healthcare workers or work in the lab, or maybe even cashiers at grocery stores that have a really high volume of seeing members of the public, that maybe they could still qualify for workers' compensation. But if not, then they may bring suit the same way that a customer or patron would, where they would say, I've been exposed to this disease because you, as an employer, as a business, failed to properly protect me at the bowling alley, at the restaurant, at the nail salon. And I think that's what employers are really afraid and trying to balance right now, is how to protect their employees, how to protect the customers, how to and not be potentially subject to liability. So I think it's important to think about this from an employer's perspective, of where they don't want to be subject to a lawsuit because they didn't exercise reasonable precaution.
You've talked about all this gray area, and given that there are so many unknowns, what is your advice or your recommendation to the average citizen who's watching this and wondering, what do we do now given that we never experienced this sort of thing before?
There's all this ambiguity about the legal liability issue right now, and there are calls by Senate Majority Mitch McConnell and the Chamber of Commerce to say we need to have immunity, we need to have safe harbors. There's going to be a pandemic of lawsuits as a result of this, and I just want to acknowledge that it's very hard to prove a lawsuit in this area. It'd be very hard to show that you got the virus at that business on that day because that employer didn't exercise reasonable, prudent care. So I think it's important to think that if that does get stripped away and there is no long and there is immunity, then businesses may not act as prudently as they otherwise would to protect the public. So to keep that in mind regarding potential liability and immunity and what that means for you as a member of the public.
Okay, Tara Sklar from the University of Arizona College of Law. Thanks for your insight.
Oh, thank you so much.